The Dark Side of Practice. An Insider's Look of the Dirty Side of Personal Injury Legal Practice. By Alexander Mirvis, in loving memory of a dear friend, Lena Savinster. Working with you was a blast, and you were a talented and brilliant complex litigation paralegal. No part of this book may be reproduced or transmitted in any form or by any means whatsoever without written permission from the author, except in the case of brief quotations embodied in critical articles and reviews. Copyright C. 2021 Alexander Mirvis. Please visit alexandermirvis.com for more information about Alexander Mirvis. About Alexander Mirvis. Alexander Mirvis is a professional settlement negotiator that works with multiple law firms throughout New York City to resolve highly problematic cases. With over $15 million and more in settlements on record, Alexander Mirvis has established a very impressive reputation as a personal injury and medical malpractice settlement negotiator. This book is not only his story on how he became one of the most prolific settlement negotiators in New York City, but also about the dark side of personal injury practice and its never-ending battle between insurance companies who will fight to the end to save a dollar and the plaintiffs' attorneys who are trying to recover as much money as possible for their clients' alleged injuries. General disclaimer: all good attorneys, paralegals, and settlement negotiators use foul language, are overly aggressive, narcissistic, and at times ruthless and effective at putting people down. This book is not for the faint of heart. If you are hypersensitive to mean words, this book may not be for you, and especially your kids. The publisher and the author have used their best efforts in providing the most accurate medical and legal information. However, they make no representations or warranties concerning the accuracy of this book. Law has a long spectrum of gray areas. I operate deep in between those gray areas. This book is not meant to be a legal or medical reference, and is not intended to teach you anything. With that being said, you can expect to have many steps, procedures, explanations to be very vague. Neither the publisher nor the author shall be liable for any medical or legal decision you have made based on any text in this book. The reader shall assume all responsibility for the use of the materials and information in this book, as well as adhere to all applicable laws and regulations at city, state, and federal jurisdictions. Medical disclaimer. I, Alexander Mirvis, am not a doctor. Under no circumstances are you recommended to diagnose your injuries or reference this book for medical guidance. Maintain common sense. If you are experiencing pain due to injury, consult with your doctor, not with this book. Do not be stupid. Legal and more general disclaimers. I, Alexander Mirvis, am not a licensed attorney in any state. All of the cases that I have ever negotiated and eventually settled have gone through the necessary processes of authority. When I get an offer from an insurance company, that offer is relayed to the attorney, who then discusses the offer with the client, and the decision is ultimately left with the client. This book is not intended for legal advice. If you have any specific issue or questions regarding any case or legal matter, please consult with your attorney. 1. This book is not a form of legal representation or legal advice. I am not an attorney. In fact, this book is not specifically written to give you any specific advice or help you settle a case. This book is more of a platform for me to vent about my job and expose the stupidity on both sides of the aisle between the plaintiffs and the defendant's sides. 2. This book is not a form of medical advice. I am not a doctor. So do not start diagnosing your injuries based on my book. Do not be stupid. If something hurts, go see an actual doctor. 3. As a settlement negotiator, I do not have complete authority to settle cases. Any offer, which I obtain from the insurance company, is relayed to the attorney, which in turn is relayed to the client. The attorney helps the client to decide on whether to accept the offer or to litigate the case or take the case to trial. If an offer is accepted by the client, I finalize the settlement. Ranting disclaimer. In this book, there will be a lot of ranting about attorneys, clients, and insurance companies. I would like to point out that not all attorneys are bad, not all clients are bad, and not all insurance companies are bad. My ranting mentions are specific to certain events that I have experienced. I have had the pleasure and the honor of working with some of the smartest, honest, and dedicated attorneys, which includes my current employer, during the year 2021 when this book was published. Introduction and background. This book will expose the dark side of personal injury law practice and how both sides of the table battle it out in order to resolve personal injury matters. Both sides I am referring to are the plaintiffs, the alleged injured parties, and the defendants, who are either at fault or negligent, and their insurance carriers who defend them and will ultimately fork out money for the damages. This book is also an insight of how I think. I am highly detailed and analytical. Example, I'd even thoroughly calculated how long it would take for an average person to read this book. The average IQ of most Americans is between 85 and 115. But just like the weather, it feels like it is somewhere between 65 and 80. Depending on the number of pooping sessions you have during the week, you should be completely done with this book in about 2 weeks. Give or take a few days within the minimum margin of error due to constipation or diarrhea. I am detail-oriented, objective, and highly analytical. I am also highly aggressive and relentless when it comes to settlements. If the case is worth pursuing, I will squeeze every penny out of that case, like a pimple. This book is not only a story on how I became one of the most prolific settlement negotiators in New York City, but this book will hopefully also serve as an attempt in regaining my soul, which was lost during the years of settling personal injury cases for various law firms in New York State, by exposing the truth and hopefully ultimately fix the entire practice, on both sides of the table. I will say many things which paralegals and attorneys think, but do not want to say. This book is also designed to expose the stupidity of clients as well as attorneys. Not all clients and attorneys are stupid, but a large percentage are. You are probably wondering, who is Alexander Mirvis, and what makes him one of the top settling personal injury negotiators in New York? The answer is simple. My numbers speak for themselves. I have settled thousands of cases for millions of dollars combined. What makes me prolific is the fact that I am one of the few non-attorney settlement negotiators in New York State that settle motor vehicle accidents, slip and falls, trip and falls, municipal, federal, and even settle wrongful death as well as medical malpractice. Most settlement negotiators throughout New York State settle only soft tissue car accident cases so that attorneys could focus on much larger cases. When an attorney decides whether to take on a difficult case or not, he or she has to figure out a balance between being brave or being incompetent. The ultimate decisive factor on whether the attorney should take a case or not is money. The attorney must look at a case and essentially almost foresee the possible outcome of a case and whether he or she would resolve the case. On the other hand, an attorney may sign up a case, which may seem like it has no hope, but still manage to get good money for it in the end. I'm not the best settlement negotiator. There are plenty of people out there that I have met that are better than me. I just happen to be the only one who knows his craft so well, I can write about it in great detail. I have turned settlement negotiation into a science. I think outside the box, think fast, and will take every possible advantage you could possibly think of or not think of either of the insurance adjuster or the facts. On top of that, I can be highly manipulative. If I hear you over the phone, and if I can sense that you either have no idea what you are talking about, are not confident, or even overconfident, you can be almost certain that I will take full advantage of your personality traits. However, one thing I don't do is lie or play dirty, unless the examiner is a piece of shit. I came across those as well. I also don't do anything illegal or unethical. After all, my boss' license is on the line, and I have a reputation with insurance companies, which I would not want to ruin. For the same reason, I do not work with dirty attorneys either. No matter how much money they offer me, and believe me, I get plenty of offers. Let's assume I didn't give a shit about ethics or laws and decided to work for a shady attorney and did some dirty shit, like forge medical records, I would be done. No one would trust me, and I would lose all respect of most insurance adjusters I've ever worked with. Building and maintaining a good relationship, which is based on honesty, goes a long way with me. I expect the same from defense attorneys as well as examiners in return. If the defense attorney or examiner does not return the same courtesy, I have my ways of either getting the case reassigned or in some cases even get the examiners fired. I have done both multiple times. If you have ever heard of the cat and mouse games during the Cold War between the Russians and the US, in many cases, it is almost the same with settlement negotiations. We battle it out and then pat each other on the back on how well we fought each other. I would like to keep that kind of rapport with the examiners, so I would never jeopardize that kind of relationship just for a few extra bucks. Moving forward, I am very direct and swear quite a bit. Due to my certain personality traits and resentment for the entire personal injury practice, you can expect a lot of sarcasm, possibly humor, and hopefully a lesson. This book is not for anyone under 13 due to the heavy use of swearing. The F word is the most expressive word in the English dictionary, and I use that word a lot to express myself. If you are hypersensitive to other people's opinions, swearing, or a progressive liberal Democrat, I highly suggest you find another legal story to read. This book is highly offensive. So enjoy. Legal references. Throughout this book, I will mention certain legal references. I highly advise you purchase the print version of this book, which outlines all legal references I will mention. I also suggest you brush up on the Article 51 of the New York Insurance Law. I will make a lot of references pertaining that law. Chapter 1. Twisted Turn of Events. Going down the rabbit hole. I do not have a typical background for someone who typically gets into law and gets good at it if they do like law. In fact, I had no interest in getting into law whatsoever after I found out how much reading and writing lawyers and paralegals have to do. I wanted to do more exciting things with my life, which would inevitably have helped people, and did not want to have a typical 9-to-5 job or manual labor job either. I was never into management either. I never did like the idea of being responsible for something or oversee someone, let alone overseeing paralegals and, in many cases, attorneys, which eventually wound up happening. Imagine that, someone with no law degree overseeing attorneys. I still scratch my head over that whole concept, but in my experience, settlement negotiators run the firm. So, this is how my story began. I served over 8 years in the U.S. Army as an infantryman and served in Iraq during OIF, or Operation Iraqi Freedom, from 2004 to 2005. This was about 8 months after the initial invasion, when the insurgency began to increase in their activities and terror. I will not dive deeply into my military background, but will focus on the most pertinent parts that affected my settlement career. More importantly, the lessons I have learned that helped me become a good negotiator. Moving forward, at some point in my military career, I briefly trained with Special Forces, or the Green Berets. I am not Special Forces qualified, but I had an opportunity to train with them for 30 days in Fort Polk, Louisiana, during the Pre-Combat Deployment Training Program called JRTC, or Joint Readiness Training Center. With a pinch of luck, my unit just happened to get randomly attached to them for the pre-combat deployment qualifications. During these 30 days of training with them, I probably learned more than I did in years with my regular units. I also solidified my sensitivity to other cultures, which is also a crucial skill to have, which helped me deal with different types of people. Green Berets are probably one of the most amazing people anyone could ever meet. In fact, most Special Forces operators, such as the U.S. Navy SEALs, Army Rangers, Marine Force Recon and Raiders, Air Force Combat Controllers, and Parajumpers, etc., are, besides the training, they are highly intelligent, and all have a distinct type of personality. If you were ever in the military, you could almost see a special operator or SOF guy a mile away. These are the type of people who are not only self-motivated and determined, but can also motivate even the laziest person to climb Mount Everest. This is the type of caliber of personality it takes to be a special operator. Besides their spectacular intelligence, personality, and years' worth of world-class training, Green Berets are masters in diplomacy. They are force multipliers. During our initial missions in Afghanistan shortly after 9/11, it was mostly the Green Berets that brought all tribes, local warlords, and freedom fighters together to begin fighting the Taliban and Al-Qaeda. I am only bringing this up because, throughout the 30-day training with the Green Berets, I learned something invaluable, which completely reshaped my thinking on human interaction and diplomacy. If you ever heard of the term winning hearts and minds, you probably think you know what it means by definition, or what you heard on the media. It is more than building schools and churches in war-torn nations. The reality is, unless you are a Green Beret or at some point interacted with them as they instructed what a true definition of winning the hearts and mind is, you most likely do not. Consider this. Convincing an individual or a large group of individuals that is trying to kill you into being your friend and fight with you against your enemy is as difficult as it sounds. One simple miscalculation can get you or your buddies killed. The training I received during my very brief encounter with them became invaluable during my settlement negotiations. It helped me make a lot of friends with the top people in the insurance companies and in general. My military service is also relevant to this book, as it gives me a massive advantage over certain insurance carriers because they love veterans. With some carriers, as soon as I mention that I'm a veteran, in most cases, they fork out a lot more money on a case than they normally would. I will get to that later. After the military, I landed my first civilian job as a telemarketer at a telemarketing company selling payment processing services. This job is also relevant to what I am doing because regardless of my military background and experience, I never had any sales or general business skills. This job paid terribly, but I did learn a lot by selling a valuable service. I also learned how to sell myself. When you sell something, people do not just buy the product, but they buy you as well because they like you. Sales jobs are undervalued because they're performance-based. Hourly salary has a limit due to how many available hours you have during the day. But if you're good at sales, you have unlimited potential. Hot girls are good performers at sales. People want to see pretty faces, boobies, and legs. Charisma helps as well. Working in sales gave me a lot of confidence to deal with people who have a lot of money. A few years later, I finally landed a job with a reputable IT company that mostly worked with telecom. I have done everything ranging from software and hardware support to research and development. I got this job by accident, but I had extensive experience in the IT field prior to that. I was fixing and breaking stuff since I was 13. At some point, I was also a reputable hacker. Back in those days, hackers met in diners, not hiding behind a VPN or virtual private network that would hide your location or in a dark web. At some point during the rise of ISIS media campaign, I helped out the anonymous hacktivist groups to shut them down. It was around 2010 when I was at the prime of my technology career field. I developed amazing technology products, which were mostly in telecom. I perfected the SEO or search engine optimization coding process and was at the forefront of working for a telecom company, creating phone captioning web interfaces. My biggest accomplishments were voice over IP security implementations, which I created using Asterisk. In fact, on the side, I still do that. Part-time, I still code, and most recently, I became a YouTuber. I created various telecom hacks to troll and decimate Indian scammers and telemarketers. I've also taken old Lenny recordings and implemented them into a basic artificial intelligence bot. Lenny is a basic voice bot that is designed to fool telemarketers by making them think that they are talking to a human, but they are not. It is also designed to keep them on the phone for as long as possible to annoy them even more. At some point in my career, I managed to screw all of that up by joining a startup company to manage their team of incompetent developers. The company went under, and out of desperation of looking for a job, I was employed by my first law firm. While working for the attorney, we became close friends, and I soon referred to her as Mother Goose. And to this day, we are still good friends, and she is like my second mother to me. She is a talented attorney. However, her downside was the inability to find clients. That was mostly due to her refusal to use runners like 90% of law firms in New York City and multi-specialty physical therapy offices use. Regardless of that, when I did work with her and her main litigation paralegal, I did learn a lot. But before I dig deep into how I became a settlement negotiator, I would like to explain what it takes to become one and how someone can become a paralegal or settlement negotiator. In New York State, any circus monkey can become a paralegal or even a basic litigation paralegal. It's at a point when you begin drafting motions without copying and pasting, you can start labeling yourself as a litigation paralegal or a real paralegal. But at that stage, you need at least some form of intelligence. There are 4 levels of being a paralegal. 1. Legal aid, responsible for basic filing, some correspondence, medical records requests. 2. Paralegal, responsibilities may include basic litigation, such as summons and verified complaints, intake processing, case write-ups, and no-fault processing. 3. Litigation paralegal, more complex summons and verified complaints, bill of particulars, discovery demands, and basic motion practice, such as basic summary judgment motions. 4. Complex litigation paralegal. Complex litigation includes appeals, complex motion practice, trial preparation, and have authority to settle. My good friend Lena Savinster, God rest her soul, was a complex litigation paralegal. She was brilliant and did all pleadings by hand. There was no copy and paste for her like most attorneys and paralegals do because they're stupid or lazy. Everything was done from scratch. As a legal aid, you can expect to work for minimum wage, but as a complex litigation paralegal, you can expect to make an average of $100,000 per year for a large firm, especially if you have an LLM or JD. To start off working for a law firm, you, in theory, don't even need a high school diploma. I have met quite a few off-the-boat paralegals who learned to litigate personal injury cases, and they didn't even have their GED. What it really comes down to is finding an attorney who is brave enough to hire you and start training you from day one. That is, if you can prove to them if you have any kind of resemblance of basic intelligence. How far you will go is all based on you because most firms give ample opportunity to learn. As a top complex litigation paralegal, you can earn as much as $100,000 per year, even more than a settlement negotiator. I took a different route in my career. I did plenty of litigation such as BP, basic motions, but I had a knack for settling cases, so I branched off the typical path that most paralegals take, which is great because I didn't want to sit behind a desk all day doing litigation and filling out HIPAAs all day. I hate filling out HIPAAs, especially when you're doing bill of particulars. What's worse than HIPAAs, though? The stupid pretrial subpoenas. I think I hated doing them even more. Pro tip: if you're a new attorney, when you go on the preliminary conference, read the damn file first before you make your first appearance. Defense attorneys love to make demands for medical records that have nothing to do with the case. I have experienced a lot of situations where the plaintiff had many pre-existing conditions, which had nothing to do with a traumatic injury event, and the defense attorney made demands for those medical records. Object to the damn requests. They may not be entitled to them, and you don't want some underpaid and overstressed paralegal filling out 100 HIPAA forms all damn day. Not to mention, it will take longer to request and then to receive the medical records to be evaluated for possible settlement.